Hi, everybody. Today we're going to talk about Chapter 12, Communication Law and Regulation. This chapter is going to be discussed very briefly because in our program in Media Studies, we have a course on media law and regulation, and students who are majoring in Media Studies can take that course. However, students who are not majoring in it, you can read it in the textbook and use these brief highlights to guide your reading. So, communication law and regulation in the digital age. The First Amendment, as you know, in this United States guarantees the freedom of speech, freedom of gathering information, and the freedom of sharing that information. So it reads that Congress shall make no law restricting basically the freedom of speech or the press. However, the interpretations of courts, elected officials, legal scholars have really allowed some level of restriction. And of course, those restrictions are motivated by the interests of the country. So in other countries, in other states, there is no such thing as a First Amendment. It is basically an American invention. And in other states, in other countries, at other times, media have been controlled or are being controlled as much as possible in the given context. So the legal framework, the background of this First Amendment is that US President Thomas Jefferson had said that information is the currency of democracy. The more information people have, the more they can do with it, the more empowered they will be. And then Congress passed the Bill of Rights in 1789 at the time when there were fewer than a dozen printing presses, not too many in the country. But Jefferson said that he would take the newspaper business over having a government at any point because he valued the press so very much. The press has since taken on the watchdog function of government over the government and other institutions in society, over businesses or other interests, certainly citizens as well. And therefore, it is often called the fourth estate. As you know, government has three three parts, um, and media is actually the fourth part of the ruling power. That is the legislative, the executive branch, and the judicial branch, and plus add the media, the news media. So, a soapbox for everybody. You can talk about anything you want freely. That is the idea of freedom of speech. And in some countries, like in China, there have been attempts to control even electronic media. Silencing journalists, silencing the news media could have a chilling effect on society. It is difficult and it is also unproductive because nowadays a lot of information is available to the public freely and openly. Electronic media have become a source for a lot of people, and the internet, as part of the electronic media field, is increasingly unrestricted. And therefore, it may be too late sometimes to stop the spreading of information. If with the printing press you can stop the presses, but once something is uttered over the radio waves or over television or over the internet, it becomes a reality that cannot be undone. So why do we need to regulate the press? Sometimes we need to do that for national security issues, not to tell enemies the locations of our troops and the amount of arms that our country has. National security is one area that really needs control over media. And in 1798, the Federalist controlled US Congress passed a law, the Alien and Sedition Act, that limited freedom of speech in response to a possible war with France. So this was a time when there was a danger of an armed conflict, and anything said or written in a newspaper in a manner that would compromise the American troops, that was restricted by law. So if there is clear and present danger, the test of that clear and present danger allows to enforce criminal law, and betraying your country, betraying the interests of your nation is a criminal offense. It's not judged by any other law. So, most and basic restriction involves speech that meets both the following conditions: it is intended to incite or produce dangerous activity, and it is likely to succeed in achieving that result. So, if you say something dumb without a real chance of creating a conflict, you will not be judged as harshly as if you called people to arms. And the example in your textbook is crying fire in a crowded theater. That might create and that would create such chaos that a lot of people will be hurt. That is one example when we have clear and present danger. Other forms of regulation: prior restraint. It means that the government blocks the publication, broadcasting, sharing, showing, or otherwise distributing media content before it is done. It can only be used in cases of serious and grave threats to national security. And the example of your textbook is about a anti-Semitic publication that was first shut down, but later it was reopened because it did not pose a grave or serious threat to society, although it was in very poor taste. And the belief here, I think, is that the markets would regulate themselves. And if something becomes unpopular with the audiences would shut it off, would not use it, and it would die on its own. So, other forms of regulation, other reasons for regulation are libel, which is harming somebody's interests, hurting someone by damaging their reputation, taking away their ability to earn money, and risking to cause stress for a person within one's community by revealing things about them or by saying things that put them in a false light or in an unfavorable light. Slander is the same thing, only in spoken form. So libel is written and slander is spoken. And a landmark court case, a constitutional case, is New York Times Company versus Sullivan in 1964. That case ruled in favor of the publication, the New York Times, saying that the citizens' First Amendment rights to criticize government officials are way too important to be restricted over some unpleasant or even damaging or untrue information. So it was taken to the Supreme Court, and Justice Brennan read the opinion of the majority, saying that they rule in favor of the New York Times. The ruling fostered a robust environment for media to publish criticism of anybody, including and especially of public figures who chose to be in the public realm, finding libel only when there is actual malice and is proven to be on the minds of the perpetrator, or if there was reckless disregard of falsehood of claims that are found in the criticism of government officials or people in power. So there are other kinds of laws, such as shield laws. They protect journalists from legal challenges to their freedom to report news. And there are many other aspects of law, such as privacy violations, etc., that you will learn if you're interested. You can take MCOM 105, Media Law and Regulation, and learn about this further, or you can completely read the chapter in our textbook. It does have a lot of useful information, and it happens to be written in an accessible language. Thank you.